Cadre employment in South Africa. Origins, consequences, scholarly perspectives on reform, and the practical implementation of the 2025 legislative framework. This series examines the forces shaping public administration and the reforms designed to strengthen it. The report argues that South Africa now has a major structural reform framework for public administration, but its success will depend on institutional adaptation, political will, and stronger oversight. Public debate often treats cadre deployment and cadre employment as if they mean the same thing. The report makes an important distinction. One concerns political control through appointments. The other concerns economic patronage through the state. Cadre deployment is described as the appointment of a party political loyalist to a state or independent institution with the purpose of bringing that institution under party influence rather than ordinary public reporting lines. Cadre employment is broader. It refers to government jobs, contracts, or economic benefits being allocated because of political connections rather than merit. In the report's framing, it reinforces the power established through deployment. The distinction is more than a matter of language. It changes the response. Political influence over appointments requires safeguards in recruitment and administration, while economic patronage also demands transparent procurement, oversight, and consequences for misconduct. The report traces the idea of the cadre to the ANC's liberation-era organizational culture. During apartheid, the term referred to disciplined members who were ideologically trained and trusted to advance the movement's goals. When the ANC came to power in 1994, it inherited a bureaucracy built for the apartheid state. Transforming that public service into one that was representative, non-racial, and aligned with constitutional democracy was a legitimate and urgent task. According to the report, a policy initially framed as transformation became increasingly associated with party loyalty. The concern was that merit in senior appointments could be displaced by political allegiance. The report identifies three motivations said to drive deployment in practice: extending political influence, advancing a broader ideological program, and rewarding loyalists through patronage. South Africa's constitution sets clear standards for public administration. Section 195 requires democratic values, efficient and effective use of resources, and sound human resource practices. Section 197 says public servants may not be favored or prejudiced solely because of support for a political party or cause. Together, these provisions require a merit-based, non-partisan public service. According to the report, Mlokoti v. Amatoli District Municipality concerned a municipal manager appointment in which Mr. Mlokoti had been rated the better candidate by the selection committee. The court found that the municipality had unlawfully abdicated its discretion and set the appointment aside. The case affirmed a core principle: public power is governed by the Constitution and law, not party policy. The Mlokoti judgment established a legal principle. When public officials make appointments or exercise public power, their decisions must be governed by the Constitution and enabling legislation. A public body cannot simply surrender its own lawful discretion to party political policy. According to the report, the Mlokoti judgment remains good law, yet a gap persisted between the legal principle and political practice. The report argues that structural reform, not just case-by-case litigation, is needed to close that implementation gap. The report says the Zondo Commission's final report found the cadre deployment policy incompatible with equality, transparency, accountability, and fairness in appointments. It says the Commission also found that the policy violated constitutional provisions and the Public Service Act. The report describes the deployment committee's reach across national and provincial government, local government, state-owned enterprises, independent institutions, the judiciary, and ambassadorial roles. It says the Commission found that recommendations operated as binding directions rather than merely advice. Reform literature converges on a common approach: separate political and administrative authority, make senior recruitment open and competitive, use clear qualification and performance criteria, and strengthen independent oversight. The aim is to build a capable, representative public service where merit and professional development work together. The report describes a merit-based process for senior civil service recruitment. It proposes clear qualification criteria, open and competitive hiring, background checks, structured evaluations and interviews, performance contracts, and independent oversight to enforce the framework. The report proposes a pilot senior civil service system aimed initially at directors general. An independent agency would supervise recruitment and create shortlists. The appointing authority would choose from that list or begin a new process, while dismissals would require documented reasons. The report argues that transformation and professionalism are not mutually exclusive. Its proposed goal is a capable, representative public service where merit guides selection, performance matters, and professional development strengthens opportunity. The report identifies professional capacity as a central reform priority. It highlights compulsory training, accredited qualifications, and structured learning pathways as ways to create objective, verifiable criteria for appointments and build a stronger public service pipeline. The report argues that legal reform needs stronger oversight to be effective. Its proposals include binding recommendation powers, lifestyle audits, consequence management, and an integrity and interference log to identify undue influence before it becomes systemic. The report suggests coalition governance can create a structural check. When political power is shared, appointment practices may face greater scrutiny and negotiation. The report frames this not as a complete solution, but as a potential check and balance in political-administrative relations. The report identifies two 2025 acts as a legislative framework for reform: the Public Service Amendment Act and the Public Administration Management Amendment Act. It describes them as restructuring accountability, strengthening professional administration, and clarifying rules across the public service. The report identifies the central structural shift as a transfer of appointment and operational authority from political office bearers to administrative heads. It says the new framework separates policy direction from administrative decisions and adds stronger accountability mechanisms. According to the report, the new framework separates senior public service roles from political office. It also creates a central disciplinary register, so misconduct can be tracked across government rather than disappearing when an official changes departments. The report says statutory appointment power moves from ministers to administrative heads. It argues that this gives directors general the legal authority and protection to apply a merit-based process, keeping the decision inside the administrative system rather than requiring a court application. The report describes an expanded oversight role for the Public Service Commission in recruitment, ethics, and grievance management. It says a pending bill aims to make the Commission's recommendations binding, so irregular appointments can be addressed within the administrative system. The report describes a central register for disciplinary cases across government. It says the register can prevent officials flagged for misconduct from moving undetected between departments, using an administrative record rather than a separate court process. The report presents professional standards as another administrative enforcement mechanism. It says structured training, verifiable qualifications, and formal competency requirements make merit-based appointments easier to test and unqualified appointments harder to defend. The report's fifth enforcement mechanism is an integrity and interference log. By documenting and reporting political interference in administrative decisions, it creates a paper trail that can enable oversight bodies to intervene early before interference becomes entrenched. The report cautions that legislation alone is not enough. It identifies risks in implementation, institutional adjustment, and political respect for boundaries. The framework can change incentives, but its effect still depends on how officials and political actors use it in practice. The report identifies 3 tests for the reform framework. First, can legal provisions become regulations and day-to-day practice? Second, can ministers, administrative heads, and oversight bodies adjust their roles? Third, will political actors across all parties respect the boundaries the law sets? The report identifies a generational challenge in the public service. It estimates that a large share of senior managers were over 50 in 2024. Without proactive, merit-based recruitment, retirement could create a capacity vacuum and risk reproducing the patronage networks reform is meant to dismantle. South Africa stands at a decisive moment. The report describes the 2025 reforms as a major structural response, creating administrative routes for merit, accountability, and professionalism. But the real test is whether political will and institutional capacity can turn this legal architecture into day-to-day practice. This documentary is based on the Supplied Research Report, Cadre Employment in South Africa. Key sources include the Constitution of South Africa, the Commission of Inquiry into State Capture, the New South Institute, and the Public Affairs Research Institute. Full references are available in the video description. Thank you for watching.